wants to do a live version of your song, they have to ask you for permission. Remember, we started by saying copyright, the right to copy. You have the right to decide what happens with everything you create. Even the fact that it's gonna be distributed is your own choice. You can decide and say, I'm gonna keep this in my safe forever. Discuss through on. We said there is copyright.
Yeah.
And we said in the copyright, there's the lyrics, the composition, and the arrangement. So with that,
Not the sound recording, maybe they're just using the words. So do you think, is it the club owner who should ask for the rights, or how do we go about that?
Hello and welcome to the Sisters-in-Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we discuss matters law.
From talking about matters employment law, contracts, tax law, anything matters law, we've got you covered.
Remember to like, share, subscribe, and leave a comment down below.
Welcome to part 2 of copyrights in music. So there's an interesting sentence or thing that has come up when we were talking just during the break, and in short, if you treat yourself as a business, people will treat you as a business. But if you treat yourself as a hobby, people will treat you as a hobby. So the reason why you need to understand all these things we're talking about is because you should plan for success, right? Plan for success in the sense that assume your music is going to, let's say, generate $1 million in profits. How would you want that to be distributed? If you thought like that, maybe you would move away from gentleman agreements and into putting things on paper. So, let me go back to our conversation. And if you own land, remember this is the same way you can own land is the same way you own property. It's the same way you can own a song. If you own land, I'm sure you've seen somewhere penye zimeandikwa, this is private property. Yeah, you're not allowed to come in. So there's such a thing as trespass. You can't just get into someone's land or someone's private property without their permission. Similarly to these rights that we're talking about today. Yeah. So if you own these rights that we talked about in the previous episode, what can you do with them? And what are the limits that are placed on other people in light of using those rights?
yeah. It's a good thing you've mentioned land, because I want to ask you, if you owned land, would you not fence it?
You would.
If you had a house, would you leave and leave the door ajar?
No, you wouldn't.
Shall we?
Yeah.
So you, for your own IP, for your own work that you've created, why have you not put fences? Why have you not locked the door so people don't come in? And by that I mean protect your work.
Yeah.
There's a system of registration. And we said this last time, for copyright is registered under Kenya Copyright Board and under the National Rights Registry. The website, you can find it either through the Kenya Copyright Board website or through eCitizen. Sawa, go register your work. Everything you have, just register. I'm not saying it's mandatory, but it's good to have. If you had land, would you be comfortable without your title deed?
No,
I think
you wouldn't.
not. So just get your title deed. Let it be proof that you actually own this thing. That's number one. So if you have one song, if you've ever written a song, even if you've not recorded it, that thing you wrote, please, very quickly to NRR and register it. Sawa sawa. Now, to what you can do. See, we mentioned this.
You said NRR.
National Rights Registry.
Okay.
Yeah. Just search National Rights Registry.
All right.
You'll find where you can go. I know the internet will lead you where you need to go. Yeah. Now, what can you do with the things that we've discussed you on? We said there is copyright.
Yeah.
And we said in the copyright, there's the lyrics, the composition, and the arrangement. So with that, you see, that can be exploited by, say, if someone wants to do a live performance. So then they will need to use your lyrics. And they might need to, maybe it's a cappella, so then they don't need to use the composition, which is okay, but still, they're using your lyrics. Yeah? Maybe it's going to include instrumentals, so they're gonna get a keyboardist to play what you had envisioned in the song. So they're gonna exploit part of what the composition had. If they're gonna also use the arrangement, maybe they will decide, I'm gonna sing this slower, I'm gonna sing this faster, but still they're using your arrangement. So that means if someone wants to do a live version of your song, they have to ask you for permission. Remember, we started by saying copyright, the right to copy. You have the right to decide what happens with everything you create. Even the fact that it's gonna be distributed is your own choice. You can decide and say, I wanna keep this in my safe forever and ever. That's your choice. So the fact that it's out there is also your choice. So you have the right to decide these are the limits as to how it can be distributed. Yeah. So that's what we talk about for copyright. That's one way. And again, please don't take this as cast on stone, because there's so many ways that you can exploit your work. And by this I mean the way that a song can be recorded, the fact that it can be played live, the fact that we can have it as the soundtrack of a movie, the fact that you can use it in an advertisement. Those are just 4 ways. Imagine how many more exist. So don't ever limit yourself to only exploiting your work or using your work by, I just want my song on radio, or I want it on a streaming platform, and then that's it. Think further. What else would you do? You know, I've seen someone who has had they had a song that had a very interesting name. You know, and then a certain telecommunication brand was like, oh, that's really cool. Can we use that for our campaign for this and this thing? You know what that person had done previously? Oh no, I know actually what happened. This person had gotten a trademark for this very cool name, because it was a made-up name, but it was very fun. So they got a trademark. The telecommunication company was like, I like the way your song sounds. I'm gonna use that name. I'm gonna use it for my campaign. The guy was like, I thought you guys, so you could have talked to me. Imagine I have the trademark certificate. And you see now he was able to get money because he trademarked something that he came up with. Like it was a unique name and it's fun. So he had a trademark for it and he was able to get paid for the use of that particular one. All this to say, there's so many things you can do with your work. There's so many things you can do with the creative venture that you've done. Now to the sound recording. Again, we've said it's the thing that you hear. So it can be played on radio, or someone else can choose to use it. They can choose to maybe put it as part of a movie, put it with an ad, as the musical bed for an ad. This is usually called synchronization. So they'll take the sound recording and synchronize it to moving pictures or still pictures. So that's synchronization. Or someone else, have you ever started hearing a song and then it kind of sounds like another one? And then they start singing and it's not that one. Like the first couple of seconds were almost exactly the same as the other song that you knew. So it's not necessarily a bad thing, because we can be inspired, we can borrow from other people's work. That's okay. The thing is, just again, don't go into someone's territory without their permission.
Yeah.
So that's an aspect of exploitation called sampling. I might like the way your song sounds, the way the sound recording is, I like the beats, I like the way it's been put together, and I'd like it as part of my song. So you speak to the owner of the sound recording and say, can I sample this beat? Can I sample this particular thing and then put it in my song? So sampling is just one way to use the sound recording. There are other ways. You could pick the song and then re-record the way that it sounds. Maybe it was previously done on a violin, but then you say, I want to do it on a banjo. Maybe it will sound more funky. I don't know.
So like covers?
That's now the exploitation of the music. By that I mean the composition.
Okay.
And then now that thing that you've re-recorded, you come and put it in your song. See, that's another way that someone can exploit your own music, or you can exploit someone else's music. Another way you can do covers. Now the covers you've mentioned, now that will be exploiting the lyrics, the composition, and the arrangement.
So just before you go to covers, I had a question on sampling. That's why I almost interrupted you. So does it mean that the way we sing in church, like we sing people's songs, of course, does it mean that there are times that would combine, I don't want to give examples of a song, but there are times would combine maybe song A with song B. Or none of the like present worship guys has formed their own. Like maybe they're not adding it to any to theirs. They're adding it to, like they're adding mine to yours to form maybe another song or something. Does that really go into sampling?
Now, with sampling is very particular because it involves you taking a bit of the sound recording as it exists. So it doesn't change the sound recording. See, and again, the sound recording is the thing that you hear on radio. So it's like you just pick a portion of that thing we had on radio and then transport it to the one that the new thing that you're creating. That's sampling. But that's also another way of exploiting a work of copyright.
So like medleys, for example, how would I explain medleys?
Yeah. Like a compilation, say a mashup of songs.
Yes, a mashup of songs. That's also like this person has to get permission from these people if they have registered their rights.
Whether or not they have registered their rights with copyright, I think you mentioned in the previous episode that copyright exists automatically. The moment you fixated it in a tangible form, so that means you've written it down, you've done a voice note, it's no longer in your head, it's in a tangible form. Immediately it enjoys copyright protection. So even if I don't have the certificate, I can still say, why did you misbehave? But it becomes a bit difficult for people to believe that it's you who misbehaved, because how can we be sure that it was actually yours? That's why registration is important, because in law it's called prima facie evidence that thing belongs to you. So when you produce it, people are like, okay, you've convinced me, but let me hear what he has to say. You know, that kind of thing. So yeah, with medleys, generally, when you're using anyone's work, if it's not for private use, you have to get permission. That means if I'm listening to a song on my headphones, I don't need to go ask the person for permission. If it's on their streaming platform, I don't need to go and ask them for permission to listen in my house. See, that's private use. That's different. But if I say, we're going to go to this garden and I'm going to invite all my friends and enemies, we're all going to jump to this music. See, now that's public. I've invited people. Yeah, when it was in my house, it was still okay. But now I'm inviting people to engage in this thing. So now that person, I'm going to need to tell them, I'm going to invite 100 of my friends and enemies to listen to your awesome music. Is that okay? Here's a little something for you. Thank you so much. Yeah.
Okay.
So that you have to do. If it's public, you'll have to get permission. You'll have to get a license.
So, do you know the case that involved Sitam?
That was actually
because Sitam was
I think they took up an old folk song
from a Kikuyu singer.
You will find the case online. You will find the case online because it's available for the entire public to use. This is the disclaimer I'm going to give based on that case. Simply because a song is old does not mean it's okay to use it. This was a song, it wasn't just old, it's that it's been sung in many weddings. So the fact that it's sung everywhere, you start to think that it's, the owner is not even known. Whoever wrote it is no longer known. But the owner is still very much alive. And if you recall from the last episode, we said copyright usually lasts for a term of the lifetime of the author plus 50 years. So if the author is still alive, it means they still own the copyright to the music. If you don't ask them for permission, then you're going to get in big trouble. Even if you can't find them. Even if you found the thing online and you're like, you see it was online. So long as the owner is still alive, you have to get permission.
So if they took you to court, you will pay damages?
Yeah. The court, so long as the court can prove that there was a problem here, you're going to pay damages. Okay, so that's what may have happened. And again, I say, because one of the arguments was, this is a folk song because it's very common.
Yes.
But the court, again, in answering that, the court said, simply because it's common does not mean it's a folk song, and it doesn't mean it's okay. That's why it was possible to get damages. So even for famous songs, even if you don't know who they belong to, just find out. And if you have done your due diligence, and in truth, you can't tell if it's one in the public domain or who it belongs to, just keep a buffer. You can just say this 10% from what I'll be making I'll keep aside, so that if ever I find the owner, it's a show of good faith. I honestly intended to pay you. I just didn't know who you were. At least table. Yeah, but it becomes very difficult to not acknowledge people's work or to just use it without getting permission.
Because in our last episode, I'm not sure if we recorded it, but I think in our last episode we talked about like folk songs.
Yeah.
They could belong to our community.
Yeah.
So like Sitam, for example, in this case that we're going to use,
it's already reported, so you can look it up.
Yeah. In this case now, as we use Sitam, how would you go about getting rights from a community? Because there's also some other folk song that has been reproduced again. Like somebody has brought up a new version of an old folk song. So if it's owned by a whole community, how do you go about it? Because most probably they have not registered it.
Most people don't even know.
Yeah. So now that brings up an thing to do with traditional cultural expressions. Traditional cultural expressions are another aspect of intellectual property. It is what protects the way a particular community or a particular culture expresses themselves. For example, some communities have beads. If you see someone with beads somewhere on the neck, for example, you would think, this person is likely from such and such a place. Or if you see someone with a certain shuka, you'd think this is someone from such and such a place. So that particular correlation and the way people identify themselves, bond together as a culture, that is what is protected under traditional cultural expressions and traditional knowledge. Usually they go with communities. And now you've rightfully mentioned, who do we go to? There's a Traditional Cultural Expression and Traditional Knowledge Act in Kenya that came in 2016, thereabout. Now, the county government has been appointed as a trustee for those particular aspects of rights. So if there is a certain folk song, and be sure that it's a folk song, that I say simply because a song is very common, simply because it's sung in your community at every event, does not mean it's a folk song. Because in this particular case, the owner of the copyright work existed, and they came and said, this song, I wrote it myself. So even though it was common, it wasn't a folk song. Yeah. So yeah, just make sure that it's a folk song, and when you're sure, approach the county government of the particular community. Yeah, I think counties have been grouped together in that a certain county would have majorly a number of people from a particular community. So approach a certain government from that community and see if they're the ones that hold custody to that particular body of work, and if they can give you permission to use it.
Okay, just a quick one. Before we went to this Sitam case, I wanted to ask on clubs. Yeah, the clubs play music from different guys.
Yeah.
Do you think they need to get permission? Because you see now, like a DJ would come up with a trail of songs, like from this song to this song, and we back to this song with one soundtrack or something like that. Do you think, because now they're using words, not necessarily,
that sound recording.
not necessarily, like not necessarily they're using that thing. What did you call it again?
The sound recording.
Yes, not the sound recording. Maybe they're just using the words. So do you think, is it the club owner who should ask for the rights, or how do we go about that?
And while you're at it, so that you just tie it in together, also radio. You know, on radio or on TV, you know what you choose the song that wanataka kuchezea. So you say this is what you want, and they keep playing people's songs back to back. Are they supposed to get permission from the owners of this song? And if they play their songs, are they supposed to be paid?
To your question, yes. And you have asked about clubs. Remember how I said the moment we've gotten out of our houses, we're playing music out of our houses, out of our headphones, we have to get a license. So the club, you're inviting guys, your friends and enemies, we come, we dance and we drink. So you have to get permission. The same way for radio. You're inviting everyone in the country to tune into your station and then hear music. You have to get permission.
So how does that happen? Do they have contracts with the owners of this song? Because these guys do these things on a daily basis.
Don't you think it will be very cumbersome to have a contract with every single person?
Yeah.
So
right? Now that's part of that is what informed what we now know as collective management organizations. And the history of CMOs is way back when a couple of musicians found out that clubs of the day were playing their music and they never got paid. So they went and they were like, this one guy went and was like, you're playing my music and you're not giving me money, and people are paying to enter. Why are you not giving me money? The club was like, Kwani utadu? You're one person. It was like, you're right, I'm one person and you're a huge club. They went and then they talked with other musicians and everyone was like, it happened to me too, and me too, and me too, and me too. So if it's happening to 10 of us, if 10 of us go, the one club manager won't be able to chase us all away. So they went together. That was the birth of collective management organizations. And the idea is to collectively manage your rights. So that means, because now we're one big massive thing involving 10 people, if you want to get our rights, you have to go through us. If like Emma is the weak one of the group, they have to pass through all these people before they get to Emma.
So it's like
Which
a
gives
union,
us
like a teachers' union.
Exactly.
Yeah.
So it was like unionizing for copyright holders.
Okay.
That's the idea. Now, my call to action here is to advise any Nsani. If you are a producer, we've identified that we are producers, we've identified labels, we've identified performers or vocalists, we've identified musicians, we've identified copyright holders, whether it's authors, arrangers, or composers. All of them, we've identified you. Find out which CMO is going to help you, because that person is the one that has been given the muscle, even by the government. That's why you will hear every year, such and such a CMO was denied a license, or such and such a CMO was given a license, because they have to be licensed by Gava to say, it's fine, sawa, you go collect for your people. Now that particular body has been given the muscle by government to go to a radio station and say, I see you played the music of Bev and Aquila and Emma, give me their money. That's it.
So you played this music this number of times.
Yeah. Now, the ins and outs of how it works, I don't know. Maybe you can join and propose how it could work better. If you're not a member, please join. And then tell us how can it work better, honestly. Yeah, but that's basically what it's about. So conversely, because as we are members of this CMO, what we're saying is, quite honestly, I can't handle 200 people coming to me to say, we like your music, can you play it in our radio station? So I'm going to give you permission to allow other people to play my music. So if anyone comes and says they want to play my music in a live event, you can allow them, collect the money, and then give me 80%. You know. So again, ideally, it will give the CMO permission to give other people licenses on your behalf.
Okay.
If you run a club, it's possible you need to get a music license every so often. And then that music license you pay for. If you're found not having a music license, chances are someone from a licensed CMO is going to come and shut you down.
Okay.
It might have happened to you and you might have wondered why. That's why. So licenses are given, and usually that license you will obtain from the CMO, because it's easier to get it from the CMO, like it's a collective. So again, if you're not a member of a CMO, nani atakutetea? Because you can't go to the radio station yourself.
Yeah.
So even if they're not working, they may not be at the optimum, but they are there. And you being there, again I said, you are the one who can see the problems. Me, I just know what the law says. You're the one who can see the problem. You're the one who knows how it could work. Join. Try and make the change from where you are. Yeah.
So how can I, let's say I'm a musician and I have my song or my sound recording, I'm a producer, where can I get these CMOs? Are they just in Nairobi, or can I ziko mashinani as well? As in
How do you join?
how do you join? How do you?
Yeah. Remember how we said everything is going to stem from understanding where you fall.
Okay.
So if you are a copyright person, you will identify which CMO is for copyright people.
Okay.
If you are a producer, you will identify which one is for producers. If you are a performer, and performers there I'm including vocalists plus instrumentalists or session musicians. I'm including them there. If you are those ones, then you identify which one works for you. I'll give examples of those that have existed in the past. I'm not saying that these ones exist now. Depending at the time of the airing of this, I don't know if they'll have the license, but MCSK, in full, MCSK is Music Copyright Society of Kenya. You see, that's to deal with music copyright. So if you are a holder of copyright, your name should be there. You should be a member there, so that they help collect for you and they help administer. That's an example. If you are a producer or a performer, these two merged. It used to be Camp and Prisk. Now it's called PAVRISK. Performers and Audiovisual Rights PAVRISK institution here. Yeah. Performers and audiovisual rights have risk. That one is, if you're a performer, join there. Come. If you're a producer, Kenya Association of Music Producers. If you're a producer, that's where you should have been at that time, when it has a license. At any time, as you join, make sure it has a license. Check if it has a license. Check, all those things. Just do your due diligence at any time. Yeah. Now, if it is in Mashinani, I honestly can't speak to that because, again, I don't know if they are licensed. My advice to any person that is planning to join in a CMO, whatever one you have identified, check. Check if they have an office near you, if it's going to be easy for you to access them. Check what the requirements for joining are. Sawa. So just do your due diligence. I don't know. But maybe there are those that are in Mashinani. But thank God for the internet, because now things are very simple. Yeah. You can just check on the internet and see. It's possible you can even register on the internet and then just be done with it. Yeah.
Wow, that's interesting. So in short, you don't have to go to the radio station. Join a CMO. Join a union.
Join a union. You could go to the radio station, but I don't know if they'll allow you in.
Yeah, I actually even wanted to ask. So if they pay for the license, let's say Club A pays for the license, it means that every singer or copyright owner who is a member of the CMO gets a piece of that license. And also, just a quick question: if your song has not been played, or are they going to monitor if your songs were played in this and these clubs?
That's also something I'm concerned about.
You see, that's why I'm saying, you guys are musicians, join the CMO and suggest these things. Yeah, and like I said, I don't know the ins and outs of how the CMOs work, but ideally it should be like that. But do we have the muscle to send people to every single club to see? Or how do you see it working? How do you see it working? Maybe you suggest. By the way, people suggest, comment down below. Suggest how we can make it efficient. To wrap up on the conversation with to do with licenses, these usually work where it involves public performance. Remember, we said if you've called your guys to your house, that's okay. But if it's a public performance, you are having an event, you're a radio station, you're a club, and you're gathering people there, that will require a special kind of license. These licenses from collective management organizations make it easier, but licenses come in all shapes and sizes. So if there is a different thing that you wish to do, if there's a very specific song, and I'll make reference to the case that you mentioned regarding Sitam and the Kikuyu song that they put in their medley. That, you see, that was not a public performance. They had the intention to incorporate it into another body of work and then record it and distribute. That's different from public performance. So for that, you have to get a specific license from the owner of the copyright for them to allow you to actually record. To alter it if you're making any alterations. And alterations includes even translating it to another language, for example. So all those things, you have to get permission. So the rights that a person gets, or the rights that you get from copyright, are very, like I said, they're very diverse. And of the economic rights, there is the right for distribution, there is the right to public performance, there is the right to synchronization, there is the right to make derivative works. And under derivative works is now where we hear covers, samples, all of those are types of derivative works. Even making translations, derivative works. So all those things, you have to get permission from the specific person. This collective license we talked about earlier usually works very well for the right to public performance, because it makes it easier to just get one license that covers. It's the way you would go to a restaurant, but you won't pay the person who brought mboga separately. You won't pay the maize
You
miller
pay for the food.
separately. You pay
With
the
the
restaurant
plates,
person and
yeah.
then trust that the restaurant person is gonna pay everyone else. Yeah.
Okay. I think that brings us to the end of this second part
Yeah.
of the episode.
So I'm sure you have learned. Thank you for watching. Please remember, I almost said please. Please remember to like, subscribe, share, comment down below, ask questions. It's a very emerging area, so you might want to ask questions. And if you ask them, we can bring her back to give you the answers. So thank you for watching, and see you in part 3.
Bye.
Yeah.